So this is a Friday. There are actually two motions for rejected, two opposition. Different, basically the same issue. Good afternoon, Leslie. You good to go? All right. So council will kindly use the podium. The audio on the live streaming doesn't pick up when you move away from there. So. I don't know, your back will be to it. You'll be projecting the other direction. I'm not sure that that's going to do it. So if you kindly use the podium. Okay. Steve. I had a taco salad, which actually they have a pretty good taco salad. I'm going to do some reading stuff. You don't need to call. Nothing of interest. Try to come in, like Friday at 9. Oh, okay. Email that. Okay.
On live stream.
If you don't have anything else to do. Yeah, presumably you won't be live streaming if you try. She was parked, I thought. Did she pick up at the end? Because she was parked at the beginning. Yeah. I'm going to give them their choice. If any one juror objects, then I usually say no, because we told them at the beginning that we wouldn't have court on Friday. Sometimes they're all anxious to be done, and so you get a nod. right, please be seated. Thank you. Back to you, Mr. Buck.
Thank you, Your Honor. I've been constrained to the podium because the folks on Zoom can't hear me, folks, so I hope I'm not gonna blow you out here. We were just talking before we left about what's in the DV guide and the warnings about the co-occurrence of domestic violence and child abuse or death. And if you look at Exhibit 70 and page 45, you'll find another shocking statistic. Of the 321 domestic violence victims from 1997 to 2008, when the policy was implemented, the abusers killed 14 children as well and tried to kill more. This was a risk that was well understood by the state. And yet they did not train their people on it. So when we're talking about why this happens, ladies and gentlemen, the state is going to say, well, it happened because we relied on the professionals that we hired, Manley and Whitehall. But really, what did they hire Manley and Whitehall to do? You heard both of those gentlemen testify. They were hired to do things associated with parenting. Manley to evaluate his skills as a parent, Whitehall to provide him assistance with his parenting skills, given the diagnosis of personality disorder and narcissistic traits that Manley came up with. What did they both say about their mission? They were not asked to assess safety or do a violence assessment. The state had an obligation to do that. Presumably they could have asked one of those two doctors to do it, but they did not. And there is no evidence that they ever did. So they can't say they relied on the experts to provide them that information. Fundamental to this case, ladies and gentlemen, is the state's inability or failure to fully inform the court of what Josh Powell was doing. It is one of the key issues. You will recall when John Long was on the stand and was talking about the actual hearings when he was having his conversations with the judge about the risks associated with this case. And I asked him, would it surprise you if Judge Nelson mentioned on 6 different occasions her grave concern about ongoing bad mouthing of the Coxes, about talking about the dependency petition itself, about having this stuff happen during visitation and how she thought it was going to be bad for the kids if it went on. And he said, no, that was clearly, she made that clear. In her order, this is exhibit number 11, folks, you will find that the court specifically ordered the social workers shall immediately inform the court if there is any violation or failure to comply with the orders. That was a mandate by Judge Nelson on the state, which we have now talked about many times, and you have heard the testimony on it, ladies and gentlemen. The state simply did not provide to the court. They didn't talk about his ongoing every visit ranting about the Mormon police, about his bad mouthing the Coxes, about his support for his father, despite what he had told Manley that he wasn't supporting him. Julio Serrano, you recall, also said, I was not aware of that stuff either. They didn't tell me, the guardian ad litem, whose job it is to look out for the children's well-being. The state's response to that, I anticipate, ladies and gentlemen, is going to be the ISSP, which is a document that Forrest Jacobson provided to the court, which was supposed to provide the court updates on what was going on with regard to the dependency and the services that were being offered to the family, to Josh Powell, to the boys. The state is going to point to one page out of that ISSP where there is mention of Josh Powell being tangential when he's with his kids and talking about the Coxes and Mormons. Folks, 244 and 245 are the two exhibits. If you read those, you will see immediately, what is the state doing? They have simply cut and pasted part of Dr. Manley's report into the ISSP. Dr. Manley's report was talking about his experience and information about Josh Powell from a month before those ISSPs. You will not see a scrap of evidence that the state ever provided the court information that these violations were going on visit after visit after visit. In fact, as John Long testified, he didn't even know, which is why he told the court everything's okay, everything's going according to plan. In fact, ladies and gentlemen, if Forrest Jacobson had actually filled out the ISSP and provided in the part under visitation where it says quality, if she had said he repeatedly violates your orders and talks about things that he's not supposed to talk about and badmouths the maternal family and talks about the dependency, you know what might have happened? The reunification train might have been slowed down. The judge might have called people in and said, wait a minute, my orders mean something. I have grave concerns about this. Why is this going on? They didn't. What did the order say? It's the social worker's job. Not Dr. Manley's job, not Dr. Whitehill's job. It's the social worker's job. How is the court supposed to know if the social worker doesn't tell it? It is through the ISSP. The only thing that the ISSP shows is what the court already knew, and that was Manley's report. So, ladies and gentlemen, we know why this happened, because the state simply refused to abide by its obligations, its own policies, and its guidelines. So now let's take a look at what the evidence shows about how the state reacted to it. How the state reacted was by making a series of excuses for not abiding by their responsibilities. Their first excuse was, it wasn't our fault. If Utah had done something more, then we could have done something about it. If local law enforcement had given us more information, we could have done something. It was Josh Powell's fault. It was even, they claim, the judge's fault, because the judge told us, well, you had to do it that way. And so what were we supposed to do? Every one of those excuses has been disproven in the testimony you've heard, though, ladies and gentlemen. Sure, they claim it's not our job to investigate whether or not Josh Powell killed his wife for criminal purposes. I completely agree. But it is your job to investigate whether Josh Powell presents a risk to his children. And what did you do to investigate that? Nothing. There is no question, ladies and gentlemen, that the state had the duty to protect these children. That's why we are here. That's what you will see in the jury instructions. It was not Dr. Manley or Dr. White. It was not Utah law enforcement. It wasn't Pierce County. It was the state, and the state failed. What's the second excuse? Well, reunification is our highest priority, as we talked about earlier. You saw that in the opening slide. Well, we know that's not true. That excuse has been shot out. The next excuse, well, the real concern was Stephen Powell and the weirdness associated with him in the house. Well, we know that's not true either, because that's not what John Long told the court when they were trying to get the kids into custody. Sure, that was one of the issues, but what was the overriding issue? You've heard me say it many times, ladies and gentlemen. You've heard it from John Long's own mouth. Only person of interest. Next excuse, well, it's really a child porn or sexual assault issue. Well, no, that's not true either, for the same reason that we just talked about. The state's next excuse, well, we couldn't do an investigation anymore. We ran out of time. We had a timeline we had to meet. But you heard Betsy Rogers testify. Well, sure, we have timelines, but if there's information out there that we need to get, we can extend the timeline. That excuse doesn't work. Next excuse, well, we had to expand visitation because Josh Powell was progressing. He was doing what he was supposed to do. Again, we've covered this many times. Josh Powell may have been going to the visitations like he was supposed to. He may have gone and seen Dr. Manley. But did he do what he was supposed to do in any of those things? No. He violated court orders. He lied to Manley. He faked good on the testing. He created a situation where the tests that were supposed to be used to evaluate whether or not he was able to be a good parent were not valid. That's not progressing. Manley's report, remember the email from Jane Wilson to Betsy Rogers, Manley called, shred my report. It was all based upon Josh Powell's lies. Their next excuse. You couldn't have foreseen this. Well, their own expert, Mark Gates, said, these risk factors show there's a risk of suicide and homicide. It may be a small risk, but that doesn't mean it's not a risk. Their own BV guide talks about this is a significant co-occurrence. Child abuse and domestic violence. This is absolutely foreseeable. The state did foresee it. They did create a policy to deal with it. The boys were starting to remember. There was a sign. What did John Long say? It is well recognized that in DV situations, in criminal law situations, if there's somebody out there who knows what you did wrong, the risk of retaliation goes up. Josh Powell was showing paranoia. Mark Pete says that's one of the things you look for danger. He treated the kids as possessions. He exerted unusual control over them. All standard signs that there's a potential problem. This was absolutely foreseeable. Their next excuse, well, the GAL agreed with the move. Well, in a familiar situation, ladies and gentlemen, what did Julio Serrano actually testify to? Well, they didn't tell me any of this stuff. They didn't tell me that they felt he was an abduction risk. They didn't tell me that he was violating the court orders at virtually every visitation. They didn't tell me about law enforcement's concerns. They didn't tell me about Jennifer Graves' information to Rocky Stevenson. All that stuff would have been important to me. Why? Because his job is to look out for the kids. So with regard to law enforcement, ladies and gentlemen, the state seems to be saying that law enforcement's lying, that they didn't actually tell them that they were concerned about the boys' safety, that Josh Powell might hurt them. And I need go no further than Mark Gates' statement. Will you take some things with a grain of salt? Who here has a motivation to say something like that didn't happen? It's the state's actors. Who here does not have a dog in the fight? Law enforcement. I leave it to you to decide who's telling the truth. Next excuse. Well, it's just an allegation. We didn't have any proof that he actually killed his wife or caused her disappearance. But you heard witness after witness get up here from the state and say, all the stuff that we investigate is allegation. There wasn't any proof the boys had been actually exposed to child porn. There was no proof that there was potential sexual assault out there. There was no proof of any of the things that were in that allegation list. But they still had the obligation to investigate and make sure that they understood what the parameters were around those allegations as it affected the safety of the children. You can't carve out the overriding allegation and say, we couldn't investigate that for no proof, without saying, we really didn't have anything to do at all with regard to any of the allegations. And of course, we know that's not right. Your next excuse, well, there was really no information to gather. Only one problem with that, ladies and gentlemen. They had lots of stuff they could look back into. Remember the original 4 intakes? Caregivers who were concerned enough about what the boys were saying that they called in and said, hey, you guys better look at this. They're threatening to kill kids. They're doing things that little kids don't do. They're saying things about their mom. Did Rocky Stevenson testify? He went out and checked into those people, asked them more details. Remember, one of those intakes said that the principal has kept a list of all these strange things that Charlie's been saying. We went out to get the list, talk to the principal. Maxwell say, I suspect pretty much everybody in the Western Hemisphere had heard about this case. It was in the media constantly. There were people being interviewed all the time who knew the pals, who knew the relationship, who knew the coercive economic control, who knew the risks that they had seen. All you have to do is call them. And what did Park Dietz say? You can't rely on the media interpretation. You should call them. Of course they should call them. That's what is mandated in your policy. Get as much information as you can to figure out what the risks are to the kids. That was Rocky Stevenson's job. He didn't do it. No supervisor from the agency ever came to Rocky Stevenson and said, why didn't you do this? Why are you not following up? Why are you not following our policies? Their next excuse, ladies and gentlemen, is, well, we couldn't do any investigation because if we found information, we would have to put it in a report and Josh Powell would find out about it and that might jeopardize the criminal investigation. There's only one problem with that, is the lead detective for the criminal investigation testified. I never told him that you can't go out and talk to these people. Their knowledge about these people was already out in the public. And if that was true, and not just an excuse, as plainly was, if that was true, why didn't the state tell the court about the things that Josh Powell already knew about? Like they found Mommy's body in the desert. Which happened to this issue where Josh Powell was. If that was going to undermine something, Josh Powell already knew. The reason that they didn't do this, folks, is because he just didn't care. All of it. Just another excuse. Who did they interview? Well, they interviewed Chuck Cox, interviewed Jennifer Graves. They both warned them, gave them information about domestic violence, about economic coercion, about the things that they were supposed to be looking out for. And their information was ignored. What did they get otherwise? Well, they had volunteer collateral people. They had Nancy LeMay, who painted a very, very different picture of Josh Powell's parent, what the state was seeing in visitation. Boing, here's your red flag. Did they follow up on it? No. They ignored her. Basically, ladies and gentlemen, the evidence shows that the state simply trusted Josh Powell when he told them things about his history, about his background, about what had happened with his family. They trusted him, notwithstanding the fact that the very professional that they hired to evaluate him for his parenting skills told them unequivocally that he was not truthful. And they closed their investigation with that paucity of information, knowing that seminal, potentially backbreaking evidence, the incest images from YouTube. Well, gentlemen, Rocky Stevenson told us this is the way their investigations go. This is standard operating procedure. And Joan Rycroft has been hired 28 times. Now, I anticipate, folks, I don't pretend to guess all of it, but I'm anticipating the state is going to say in closing, boy, we did a lot. Look at all these emails that were sent. Look at all these telephone calls, contacts with law enforcement. We went to the hearings. We checked the boxes in these forms. But if you look closely at those activities, there's a word for that. We call it busy work. Push in the paper. None of the things that the state did actually accomplished what their policies required, and that was a thorough investigation and assessment of the risks that those boys faced. They did what they needed to do to let the reunification train rumble down the track. You know what I think the state will not talk about, ladies and gentlemen, is their policies. I think they're not going to get in front of you and say, this is what our policy says, and we abided by it, for reasons that I'm going to talk about in just a minute. The truth, ladies and gentlemen, is that everything that's happened since this has been a cover-up. The state was caught having not followed its own policies, having ignored specific warnings, having not taken the precautions that it should have taken, having not put the children's safety first. Evan, let's look at slide 32. And we can pull this up. You saw this with Forrest Jacobson's testimony. Next slide. Forrest was responding to Paul Smith, who she described as some supervisor at the agency. I can't remember exactly what she said. Just take a moment and read through this, folks. She was asked to explain her thoughts on the decision to move the visits to Josh's home. She talks about the agitation at FCRN, which Elizabeth Griffin Hall, who was actually at the FCRN visitation, said, no, that never happened. She talks about Josh bringing complicated projects to prepare meals, and that there was extended overtime goodbyes. Well, those are all issues that the department is supposed to stay in check on. That's Josh Powell misbehaving. Why would that be a reason to put it at his house? To reward him for doing what he's not supposed to do? The idea that the new home removed the threat identified in the dependency petition. Well, that's not what the state workers told you, folks. They told you that the risks had not been alleviated. The risks that originally sat out there that caused them to be concerned about the boys were still in play. Whether or not Josh Powell was involved in the porn, whether there had been sexual abuse. The overriding issue, was he responsible for his wife's homicide? None of those had gone away. I had a conversation with Elizabeth about her comfort level in doing them at the house, and she did indicate that she felt as though it would be better and inform me after the first visit. Ladies and gentlemen, what is missing from this email? What is missing is this line. We followed our policies. This kind of thing was so unforeseeable that it couldn't have been avoided. That would have been the appropriate answer if they had done things the way they wanted to. This is all just creating an excuse for doing something that was against their policy. And what did Betsy Rogers say in response to this? Thanks. I also like the piece you also mentioned to me that for this father, there were no major mental health diagnoses, as noted by Dr. Manley, that would have supported not having visits in the home. Nowhere, including all the way up to the level of the supervisor, do they mention anything about their policies and what the visitation policy required, what the DV policy required. Folks, this is coming up with excuses for failure. Now, ladies and gentlemen, you were shown a series of red flags in Jane Raymond's testimony. We're not going to go through them all. I touched on a whole bunch of them without describing them specifically as red flags already today. But just as we take a look here, Susan's disappearance, the boys are placed in custody, visits are moved to Josh's home, Josh murders the boys. As this process went on, the state was provided more and more and more reason to be concerned about the safety of these boys. And as it got closer to February 1 and the court's hearing, ladies and gentlemen, that risk simply exploded. The state took no action. He lost Tim Atkins. He wasn't going to get his boys back. He had to do the psychosexual. He had to do the polygraph that he was so concerned about. So we can graph what happened, ladies and gentlemen, remembering that the state's obligation, its primary obligation, is the safety of the children. And I think this pretty much tells you exactly what happened in this case. Give you just a moment to pull it up here. If we graph this out, folks, your vertical axis is the level of security. You can see the highest level of security is the DSHS office, which incidentally is what the parenting plan or the visitation plan called for visitation. Or other pre-approved DCFS facility, so the equivalent of a DSHS office. What's the next safest place? Well, FCRN, where several of the visitations took place, where they had the key fob and the alarm and doors that locked and those kinds of things. What's the next lower level? The Atkins home. Tim Atkins, you heard his testimony, took it upon himself to be more cautious than the state's agent, Elizabeth Griffin Hall. He actually went out and met the car when it came into the driveway to make sure that he was in control of the kids. He did things that the state's own agent did not. What was the place that had the least protection? Josh Powell's home. And what about the level of risk? At the beginning, there was child porn, potential sexual assault, being a person of interest, the overriding one. But then the state learned of the boy's statements. It learned of this incest images. It learned that he was going to have to undergo a psychosexual evaluation and polygraph. Ladies and gentlemen, as the red line is shooting through the roof, what is happening to the level of safety of the visitations? It's falling to the lowest level. That is not abiding by your duty. This is a case about negligence, ladies and gentlemen. Negligence, you will see in the instructions, is a failure to act as a reasonable person would under the circumstances. And what would a reasonable person do under these circumstances? Well, you take precaution. You'd follow your policies. You'd follow your guidelines. You would do a DV assessment. You would do a safety assessment. You would do a risk assessment. You would follow the therapist's advice about who should be overseeing the visitations. The state's expert, Mark Dietz, agreed. Follow your policies. That's what you're supposed to do. Dietz and Raymond both said, investigate the risk factors that you're aware of. Dietz said, follow the court orders. Dietz said, err on the side of caution. Raymond said the same thing. Of course, that's what a reasonable person does when they have care and custody of two helpless little boys. The state failed to act in a reasonable fashion, ladies and gentlemen. They failed to follow their own policies. They failed to follow the standard of care of the industry. You will see in the jury instructions that failing to follow a policy is evidence of negligence. Well, here it's overwhelming evidence of negligence because the policy existed to accomplish the goal of the safety of the boys, and they didn't follow it. The result was the tragedy that we are here talking about. There are a couple of instructions, ladies and gentlemen, that I want to particularly draw your attention to. Jury instruction number 13 talks about the duty. And it says, in this case, the state had a duty to exercise reasonable care for Charlie and Braden Powell when they were under its care, custody, and control. What does it say about the duty to exercise reasonable care? It extends to risks that are foreseeable. The foreseeability of the risk of harm is not limited to the actual harm suffered. They don't have to foresee that he's going to hatchet, douse, and burn his children. But rather it is determined by whether the actual harm fell within the general field of danger which should have been anticipated. In other words, the general field of danger that is identified in the state's own policies. I'd also like to point your attention to instruction number 17, ladies and gentlemen. This is our burden. We're the plaintiffs in this case. We have the obligation of proving negligence by a preponderance of the evidence. In other words, that it's more likely than not that the state was negligent. But one of the elements of it is that the state's action proximately caused the injuries to Charlie and Braden. What does number 17 say? It says the term proximate cause means a cause which in direct sequence produces the injury complained of and without which such injury would not have happened. Without which such injury would not have happened. The next instruction, ladies and gentlemen, number 18, talks about the fact that there can be more than one proximate cause. In other words, many different things can come together to cause one injury. All you have to do is prove that one of them was caused by the person who was being held liable, in this case, the state. The fact that Josh Powell may also be a proximate cause is not relevant. What is relevant is whether the state proximately caused the injury to these boys. And that's laid out in the next instruction, ladies and gentlemen, number 19. In calculating the damage award, you must not include any damages that were caused by the acts of Joshua Powell and not proximately caused by the negligence of the defendant. What that instruction is telling us is what we know to be common sense in order to make sure that victims are compensated for what they've gone through. You distinguish Josh Powell's actions only if his actions were not, or if the damage caused by them was not also proximately caused by the state's failure. And that is the key to the negligence assessment. If the state had followed its policies, its guidelines, common sense, investigated, had visitations where it was supposed to have them, none of this would have happened. It was in direct sequence that these boys were allowed to be given to their father in an unsecured facility where he could do the awful things that he did. So I'm going to close, ladies and gentlemen, with a little bit of a discussion of the impact of this negligence. And let's put slide 37 up. This was a beautiful family. Susan's out there someplace. Long gone. Her boys were still there. And these parents, these grandparents, stepped in. Chuck and Judy took the reins that were left when their daughter disappeared. Let's show the next picture. It's no small task. You've got two rambunctious little boys running around. But what did Paula Strickland say? Paula Strickland loves the Coxes. She talked about how hard they worked, about how attentive they were, how they worked with her to make sure that things would go as well as possible. These boys, ladies and gentlemen, their last moments, as we talked about, and you heard from the forensic experts, they were awful. They were absolutely awful. The brutality, the panic, and as I mentioned in opening, folks, the betrayal of your father doing this. I can't even begin to imagine what must have been going through those boys' minds as they saw that hatchet come out and they felt those blows and that gas was poured on them. A little boy's mind. What is going on? Swallowing gasoline, the utter terror of it. Let's play the 911 call. Ladies and gentlemen, that visitation occurred with the supervisor recognizing that Wednesday's hearing was a big deal. It was a big new risk. And what they do to prepare for it? She doesn't even know the address. There was no safety plan. There was no effort to stay with the boys so she could intervene. There was nothing done to protect them. And somewhere between that call and the next call, where she reported that the house was on fire, these two beautiful little boys choked and seared and eventually died in that house. Ladies and gentlemen, you heard Dr. Weck talk about how long this may have taken, how long they might have been conscious. You're going to be the final arbiters of what went on. But we do know something about the timeline. From the CAD call, so the next slide. The first call came in at 12:08. At 12:12, as you heard from stipulation when this was first played, at about 4 minutes and 15 seconds into that call you just heard, Elizabeth Griffin Hall told the operator that the boys had been in the home about 10 minutes. That means the boys went into the house presumably around 12:02. Let's go to the next. At 12:15, the first 911 call ends. We know at this point the boys have been doused in gasoline, but there's no fire. What's going on? At 12:24, Elizabeth Griffin Hall makes the second 911 call. The house has just caught on fire. We know the boys are still alive because they died of carbon monoxide poisoning with soot in their windpipes. It's 21 minutes and 44 seconds. If Elizabeth Griffin Hall is accurate in her estimates. We know that they were conscious for some time because, ladies and gentlemen, they swallowed gasoline. It was in their gastric content. It was in their blood. It made its way all the way to the vitreous of the eyeball. The forensic experts all agreed you can't swallow when you're unconscious. Now, Dr. Nelson, the state's expert, said, well, it must have gotten in some other way because it wasn't in the urine. But ladies and gentlemen, if you look at the toxicology reports, what will you find? The urine was never tested for alcohol. Dr. Nelson is flat wrong. I suggest you pay attention to the actual ME who did the autopsy and told you most likely this got in their system by swallowing. I suggest you listen to Dr. Weck, who agrees with the ME's conclusions on it. That slow curtain, ladies and gentlemen, of consciousness, we know it overcame the boys at some point. And only you can decide when, thank God, they finally hit a level of unconsciousness where the pain went away. Ladies and gentlemen, I suggested an opening that an award of $5 million a minute for the pain the boys suffered would be appropriate. Because I can't imagine what it would be like to be in that position. Unfortunately, the only way that we can render justice in a situation like this is through the awarding of money. Money damages are the only choice. And so I put it to you this way. We consider what the obligations of the state were. We consider what options they had available. We consider what they recognized the risks to be. We consider what they actually did. And we consider the result. This incredible miserable end. I don't think I'm too far off on the value. But it's up to you. It's up to you to decide what that number needs to be and how many minutes. The only way, I will tell you though, ladies and gentlemen, to hold the state accountable for its negligence in this case, for that remarkable indifference, is to compensate these boys for every second of suffering that they went through. The state has to follow the policies and guidelines that it recognizes are necessary. That is what justice demands in this case. The state's going to get up here and they're going to say it wasn't our fault, it was Josh Powell's fault. But Josh Powell would have never had an opportunity to strike those boys down, to douse them with gasoline and burn them alive, if they hadn't been turned over to him in an environment that he had exclusive control over, contrary to the state's own policies. Ladies and gentlemen, the cruel reality of it is because the state simply failed to follow its policies and put the boys in this position now. Chuck and Judy Cox look at pictures of their grandsons instead of seeing them on their laps, pictures that have exhibit numbers on them. Just contemplate that for a moment. There are certain questions the state simply will not be able to answer, ladies and gentlemen. I'm going to put the challenge out right now. Why was no collateral investigation done when the policy specifically required it? Why recognize and develop a policy to address significant co-occurrence between domestic violence and child abuse and killing, and then utterly ignore it? Why, if you followed policy, did you have to scramble to come up with an excuse for why the visitations were taking place at a location that could not ensure the safety of the boys? And frankly, the most important one, ladies and gentlemen, why was visitation moved when it was contrary to policy and the risks to the boys were increasing by the week? The state does not have answers for those questions, ladies and gentlemen. Thank you. You have been an incredibly dedicated jury. I don't know that the state of Washington has experienced something as unusual as what you've gone through, but to come back and finish this job means everything to the Coxes. We appreciate it immensely. I leave it to your good faith, to your memory of the facts, to your assessment of the law, to determine what to do. But mostly, ladies and gentlemen, I leave it to your sense of justice. These boys had a chance to grow up. They had the right to grow up, not to die like that. Thank you very much.
Thank you, Mr. Bob. We'll wipe down the podium and we'll do our podium stretch.
It was by me.
Yes, ma'am. I think that you can. And Mr. Diaz, about an hour in, we're going to be taking our afternoon recess, just to give you a heads up. Okay? I don't know anything else. Yeah, it's harder to get a sense of it. All right, please be seated. Please give your attention to Mr. Diaz. He's going to deliver the closing argument for the state.
Thank you, Your Honor. If it please the court, ladies and gentlemen of the jury, Mrs. Cox, Mr. Cox, Cox family. This will be the only and final time that you hear from the state in this matter until we have the opportunity to talk to you after you've come back with whatever decision you're going to be making. Now, we would all recognize that we've been on a very long road together here, started back in February. And all this time, in order to address a very tragic incident, one which most of us will never forget, one that was not foreseen by the state. Now, why do I say that? And I say that because of what is occurring is what we would refer to, and you've heard throughout the trial at various stages, hindsight. Hindsight biased, armchair quarterbacking, second guessing. You've heard throughout from the very beginning an opening statement, spinning of what the actual evidence and facts is in this case. There's no ifs, ands, or buts that it was a very tragic matter. But the state, and we're going to show you in a moment, that the state took this very serious. They did their job, they followed their policies. And what we're going to ask of you is to evaluate this case based upon the information that was known at the time, and that the state's reliance upon professional evaluators, a knowledgeable court, a judge who was overseeing these proceedings. Now, as a trier of fact in this case, 12 of you will be making a decision that all of us will be living with as this chapter of the Josh Powell legacy comes to an end. As a trier of fact, the judge has instructed you on the law, state's duty that was owed to Charles and Braden a duty of a reasonable person using ordinary care to protect them from foreseeable harms. It is easy to get lost in the horrible loss of these two beautiful little boys. And only comfort is the fact, as Dr. Clifford Nelson testified here just recently, that the boys fortunately did not suffer as they were unconscious from the initial blows that they suffered at the hands of their own father. A person that these boys loved, trusted, and wanted to be with. And we heard plenty of testimony of that fact from people that had direct contact with these boys. Now, it's important to note that multiple eyes were not only on the boys during the time that they were in the dependency action, but also on Josh Powell during this time period when the state was involved in their lives. Prior to the dependency, only law enforcement was involved, and their focus was upon Mr. Powell concerning the disappearance of his wife. But after more than 2 years after her disappearance, still no arrest, no charges against Josh Powell. A man who had no known criminal adult history, a man who was fully employed, a man who was not a substance abuser, a man who had been educated, a man who was providing for his sons when they were taken from him and put into the state's care and custody due to the actions of his own father, Stephen Powell. Now, what I'd like to do is walk you through the timeline of the state's involvement in this matter to help refresh your memory, because it has been many months, many witnesses. The state tried to bring in the witnesses who were directly involved during the time period so you could hear from them, you could see them, you could ask your own questions of them, which you did. Now, what I like to do, it will go to the first slide. In this first slide, and I just moved it. If we can go back one, please. So the first involvement that the state had any knowledge concerned shortly after the disappearance of Susan Cox Powell in early December of 2009 in West Valley City, Utah. And that it became known that Mr. Powell had moved and relocated from Utah to Washington State with his sons, Charles and Braden. And that he then moved into his father's residence in Puyallup. Now, until Susan's disappearance, there was no known prior history with law enforcement in the state of Utah. And it was known that the Powells also had no prior history with child protective services in Utah, no recorded history of domestic violence or child abuse. We heard from West Valley Police Detective Ellis Maxwell, who testified here just a short while ago, sometime, I believe it was even last week, that he was not aware of any child abuse or sex abuse while Charles and Braden lived in Utah. We can go to the next slide. Next slide, please. So what we have, when the boys came into the state custody, we had law enforcement originally, shortly after the Josh Powell and the boys came to Washington, had applied for a sealed search warrant to go into the Powell residence, a warrant that was not available to DSHS, or as I'll refer to them, throughout the department. And then a search was conducted on August 25 of 2011, which eventually there was uncovered images that belonged to Stephen Powell, which depicted child pornography and voyeurism. Pierce County Sheriff decided not to place the boys in protective custody at the time the search was conducted. And you heard the testimony from Detective Sergeant Sanders, also Detective Sergeant Teresa Berg. And they had described at one point a house of horrors that they observed back in August when they assisted West Valley City, Utah police in a search of Stephen Powell's residence. But they did nothing about the boys at that point in time. It wasn't until a month later, September 22nd of 2011, Stephen Powell was arrested, and law enforcement came to DSHS and the department, told of their plan to arrest Stephen Powell, and that they wanted to place these boys then into protective custody. And that's how the state became involved. A number of people over the course of several months, starting in September through or until early February, actually, had involvement. We've listed it, a number of the people here for you. Forrest Jacobson, master's degree in social work, who at that point in time had 10 years of experience when she was involved in this matter. Rocky Stevenson, 20 years of experience in social work. Betsy Rogers, 20 plus years. Julie Slaughter, 23 years of social work. And then we had other people that were providing services to the boys. Lori Narigi, who provided mental health counseling for the boys shortly after they were put into an out-of-home placement with the Coxes, but during the course of the dependency and services that were provided. We had Michelle Breland, who testified, who is associated with the Child Abuse Center here at Mary Bridge Hospital, who examined the boys upon coming into custody of the state for purposes of evaluating for sex abuse and also physical abuse of the boys. You heard her testify that there were no signs based on her examination of those boys that would show that there had been active abuse, whether physical or sexual, of either boy. As she advised you, though, they can never rule anything out, but there is no history or facts that would support any prior sex abuse or physical abuse of the boys. We also had testimony from Paula Strickland, another master's level social worker, therapist, who provided services for the boys with their transition into the Cox household. And she was providing services for both the boys and for the Coxes, and she did so for 3.5 months. Elizabeth Griffin Hall, you've heard just ending the plaintiff's first part of their opening, which they'll have another opportunity to come back to rebut everything that I'm about to tell you, and I'm certain they probably will. But Elizabeth Griffin Hall, you could hear in her voice the shock, the terror, the unknown of what was occurring. She had not experienced anything like that. That was her 11th visit on that day to Josh Powell's residence for a supervised visitation. Over the course of the dependency action, there was more than 20 supervised visitations, and a majority of them were conducted by Elizabeth Griffin Hall. We had a handful of visitations supervised by Pastor Tim Atkins, which occurred in his residence as visitations had, through natural progression in this type of a dependency matter, they had increased over time. Then we had Dr. Manley, who at the time of his evaluation had 12 plus years of doing evaluations. You heard him testify that many of the evaluations in the past that he did were for competency of people with mental disease or mental illness or sex offenders. We had Dr. Whitehill, who testified in this case, who had 30 plus years, who also testified about his association in dealing and treating and evaluating sex offenders and people who are accused of crimes. Julio Serrano, who was assigned by the dependency court as a guardian ad litem, and he had testified that he had 17 years of experience. he was appointed by the court as a special advocate for these boys. Now, we're going to go through more information here, but as the plaintiffs have been claiming that none of these people knew what was occurring, and that is just not true. You'll see and have the opportunity, and I'm going to actually encourage you not to rely just on what notes you've taken over the course of, I believe today's 31 of our trial. And over the course of this trial, you've taken notes. But I want you to also look at the exhibits. And I'm going to go through a list of those exhibits that you really need to pay attention to. You need to be able to put it in all of the facts that you've heard over these many weeks into the proper context of what was occurring and when. Now, I'm going to recite or show you the very first time that we were aware of anything. That was on March 1st of 2010, when there was a referral, a call-in from someone in the state of Utah who was claiming that there was people in Utah that were abusing Josh Powell. That referral was not screened in, but you've heard throughout this course of the many weeks that, well, the department never investigated. They had all of these opportunities. They had these prior referrals. And you'll have the opportunity to read those referrals. Those are all exhibits that have been admitted in this case. But you also heard the testimony from Julie Slaughter, who was an intake supervisor, why they weren't screened in. They didn't meet the criteria. The department has to follow various regulations and laws as to what they're able to do and not able to do. So March 1st came in, but then also in March, the next time we had a situation which only John Long was aware of. The department was not. But in March of 2010, he testified that Detective Sergeant Teresa Berg of the Pierce County Sheriff's Department had contacted him to inform him that they were seeking a warrant in order to go pick up Charles and Braden, take them from his father, and for the purposes of interviewing them to see what they knew about their mother's disappearance. And that based on what was disclosed, that those boys may potentially be put into protective custody then. That was in March of 2010. We heard from Detective Berg, and we heard from others, including Detective Sergeant Gary Sanders, that after spending an entire day with those boys, interviewing the boys, they returned them right back to their father. And we've heard that, look at the risk. The state should have known of the risk, because if they witnessed something and they started to disclose something, well, their father, he might take out some retribution, he might take out revenge, he might do something to those boys. But what did law enforcement do? They returned him. They returned him back to their father. So March 10th was the date of the actual interview, and nothing was done at that time. The state was not contacted to be advised on what the result was of those interviews. Then we have a second referral to DSHS or CPS in the department, August 20th. Now, you've heard these facts over and over and over again. It's because it's very odd, but it doesn't rise to the level of abuse or neglect for CPS to open an investigation. This is where the YMCA had advised and called up to state that Charlie said, when you kill a bear, you dig a hole. You bury the bear in a hole, you cover it up, plant a tree on it, some raspberries. Very odd for a child at that point in time who's 5 years old. Now, we have to recall that when their mother disappeared in December of 2009, these were 2-year-old and 4-year-old boys. We then look at this referral that came in, and what did the department do? They referred it on to law enforcement, which was the appropriate entity to have this information in case it had some importance. And at this point in time, they were aware that Susan Powell had disappeared. They were aware of the importance that this information might have for law enforcement. But the department and CPS, they are not law enforcement agents. They don't have the power to go out of state and do investigations. That's important. And they don't interfere in criminal investigations. The last thing that they wish to do is interfere with an ongoing investigation, which could be detrimental to that investigation. So after passing on the information, in fact, West Valley City Police came out to interview the staff at the YMCA. And while they were here, they then contacted CPS to advise that there really wasn't anything to this burying the bear and planting a tree on it. But they requests if we got more information, if we would share that with them. And this is important because we've been accused of not doing our jobs. We've been accused of not cooperating with law enforcement, not cooperating with others. And there's nothing further from the truth. And that's why I want you to hold us to and review all of this information so you get a clear picture. Because what you keep receiving is the spin that has been going on for quite some time now. September 9th, former detective, he's now retired, Ellis Maxwell, calls DSHS to advise that they had interviewed the staff, there would be no follow-up, and again, makes the request if we would advise them if there's anything that could potentially be of interest in their investigation. The first several exhibits that you're going to see when they come back to you, and many of the exhibits are judicial assistant to the judge has placed these exhibits in three-ring binders. So the very first 3, 4, and actually the first 5 are going to be these intake referrals. Now we're going to move on to the year 2011. And that's the next referral, the third one that had come in from the state or into the state. This was also screened out, but this is where, again, at Charlie's school, he had indicated that his little brother was gone, that he'd been killed. That is not the type of a call to CPS that they have authority to go and open up and screen and do an investigation. What they do and what they did here was they called law enforcement. The Pierce County Sheriff's Department did a welfare check. They went out to the residence, Stephen Powell's residence, where the family was residing at the time, and Braden was there. And so they had reported back that everything was fine. We have a fourth referral that came in on June 10th. Again, Charlie making statements about not liking people, not believing in Jesus, bad things about the Mormons. And once again, there was no accusation or complaint of child abuse or neglect. And the department, once more, referred it to law enforcement to investigate as to any significance or importance that it may hold. And in fact, former Detective Maxwell came out to Washington State once more, and he met with Julie Slaughter and addressed that concerns they may have regarding the household and whether or not CPS could accompany them to do a welfare check. And they were advised, without an active case, we don't have authority to go to people's homes. Law enforcement has the authority to. They were working hand in hand, as you heard from Detective Sanders, who got assigned as a liaison with the West Valley Police Department early on in their investigation. He had actually testified that he was first contacted in December of 2009, but it was in January 2010 that he began working closely with the West Valley Police Department. We move on to September 21 of 2011, and there was a meeting. And this meeting occurred after the search of the house, which we had mentioned earlier in August, which then led to the boys being placed into protective custody. When the boys were put into protective custody, we have several slides of information regarding what the known risk factors in this case were. And we have from the testimony that you heard on July 15th from Detective Sergeant Teresa Berg, where she testified about the known risk factors at the time, and how she said it's easy if you have something concrete like an injury or a sexual assault. It's very difficult to show potential risk in these situations where you might think something is going to happen, but you don't have enough proof to remove a child. It actually takes facts and proof to remove a child from their parent, to keep them out of the home. You can feel like there is risk, or you can sense there is risk, but gut feelings don't count. We have to have facts, and that was difficult in this case. And that's been difficult throughout the life of this case for the department at the time that they were dealing with Charles and Braden and Josh Powell. We also had heard that from Detective Berg, she claims that prior to the boys being placed into protective custody, she had told at a meeting Rocky Stevenson, Assistant Attorney General Long, she believes that Betsy Rogers may have been present, Billy Reed Litsky, that she thought Josh Powell was going to kill his sons. But she had no facts, she had no evidence. So on September 22nd, 2011, a complaint was filed with CPS. That's Exhibit 5. And that was screened in since the boys had been placed into protective custody. Anytime children are placed into protective custody, that will be a screened in event. They were taken into protective custody back in March of 2010. They were taken into protective custody when the detectives were searching the House of Horrors at Stephen Powell's residence in August 2011. And it wasn't until they discovered child porn and voyeurism photographs that were in the computers of Stephen Powell. No accusation, no facts that there was domestic violence going on within the home. There was no facts of domestic violence known then or after that the department never learned of. Yes, the fact that Susan Powell was missing was known. But again, we need more than just supposition. So what we have here in this slide is once the boys in the meeting occurred, what happened in the life of the CPS and the dependency over the course of several months. So you'll see that there was that meeting we discussed on the 21st of September. The 22nd of September, the boys are put into protective custody. On the 23rd of September, there was a meeting at the Advocacy Center, the CAC, which you've heard those initials, where there again was no information regarding some known threat that these detectives thought there might be. We have a symbol for law enforcement, and we'll show you a slide a little later, which actually shows the contacts that the department had with law enforcement over the life of this dependency. We also too know that there were several proceedings that were commenced, because on the 23rd of September, Mr. and Mrs. Cox filed in the family court here in the Pierce County Superior Court a non-parental custody action seeking the custody of Charles and Braden. The day after the boys were put into protective custody, you heard testimony throughout the trial from not only their attorney at the time, Steve Downing, but also Mr. Cox and Jennifer Graves about what they alerted the Superior Court judge of regarding the facts that they had concerning the risk of harm, any past abuse, everything that they would want to utilize in order to support their action to remove those boys from their father's custody. And what was there? There was a hearing on the 27th of September, at which time Judge Catherine Nelson, presiding, who had before her a 10-page declaration from Chuck Cox. She had the motion from Mr. Downing. She had a hearing where Mr. Downing spoke. We had a hearing where Mr. Downing told the judge of various facts, including Braden telling his aunt, his great aunt, sometime earlier in time, that Braden pointed at a picture in the chest of a person in a bathing suit and said, "Mommy owie, Mommy owie." Information that Judge Catherine Nelson was fully aware of. And through the course of the hearing, and we also had present at that hearing as a courtesy, Assistant Attorney General Long, who advised you that during the course of that hearing, not only did Judge Nelson ask for additional information, which Mr. Downing said he would retrieve, but that what information that Mr. Long had regarding the criminal charges against Stephen Powell was given to the judge. That was shared with her. What's important about these facts? The importance is that the very next day, when the dependency action commenced and there was a hearing, Judge Nelson already had a wealth of knowledge regarding not only the Stephen Powell residence, but facts surrounding the disappearance of Susan Powell and accusations that were in the declaration that Mr. Cox had filed, that he believed that Mr. Powell was the only person responsible for her disappearance. So we have a person presiding over proceedings who has information regarding the risk factors that may be involved and the threats that may be involved as decisions are going to be made regarding the boys. So the following day, on the 28th of September, there is a hearing now because the state had filed a dependency petition on behalf of Charles and Braden. And at that hearing, the judge ordered what we refer to as an out-of-home placement with a relative placement. They were placed with the Coxes, Charles and Braden. Also, at that time, the department requested and services were commenced. We had mentioned several of the people that were involved in services, but there was also health and welfare check. We had heard over time the acronym CHET, C-H-E-T. Social worker was assigned to go and evaluate the boys' medical needs, dental needs, their educational status, so the state could start providing services to address any of those needs. It was also determined that the boys could benefit from mental health counseling, and that was all arranged and began in the month of October with the mental health counseling. Also, on the September the 26th, we did have the medical examination that Ms. Breland had testified to here a week or so ago. The department takes serious anytime a child is put into its care and custody. Moving on to the month of October, visitations which were ordered at the shelter care hearing, which was on September the 28th, commenced. The green symbols indicate supervised visitations. They occurred on Sundays as the court had ordered in order to not to interfere with the Cox's church services, which they would attend. And so that's what the order indicated, was that it would be services during that time. But during this time, we are still having contact with law enforcement. And we've got on here weekly meetings that were occurring at the ACA, the Child Advocacy Center, which Detective Sergeant Sanders would attend. An opportunity to have open dialogue based on current cases that are here in Pierce County. I want you to look at what we refer to as case notes. Those case notes are Exhibit 55. In Exhibit 55, you'll find the notes from Rocky Stevenson, you'll find the notes from Forrest Jacobson, you'll find the notes from their supervisors, you'll even find the notes from Julie Slaughter that go back to these earlier referrals in 2010 and earlier in 2011. I'd like to have you read those. I'd like to have you see what information that was relayed to them, what they include in those notes. You'll actually see in Rocky Stevenson's notes his interview with Jennifer Graves and her husband Kirk Graves that was out at the Cox residence. You can see for yourself, and we're told that, well, there's a cover-up, hiding things. What are we hiding in September? Really, what is being hidden by the department? as they're trying to figure out and get assistance by whatever means they're able to without interfering with now 2 active criminal investigations. You'll go and when you look at the petition that was filed for this dependency, there was 11 allegations. Yes, the last one talked about Mr. Powell being a suspect in the disappearance of his wife. But you'll look at those other allegations, all concern the household that they were removed from and the criminal charges against Stephen Powell. So you'll see from this calendar the various referrals that took place, various visits that took place. And you'll see even the notes in Exhibit 55 from the check worker, Ms. Saravino, and the results of her examination, the recommendations that were being made for medical checkups, dental work for the boys. The department takes their work serious. We have also in October other activities that are taking place. Mr. Powell volunteered to have a psychological evaluation with a parenting component at the shelter care hearing on September 28th. The court went ahead and put that into the order. And I would encourage you to look at each of these orders. They're important. There's information contained in each one of them. So here on the 14th of October, Forrest Jacobson, she prepared a referral to Dr. James Manley only after an attorney had appeared for Mr. Powell, Jeffrey Bassett. And you'll find emails which are part of Exhibit 270A. And I'll ask you to read those emails. But as part of that, you'll see that Mr. Bassett had a say in who was selected to perform this psychological evaluation on Mr. Powell. It was not a unilateral decision made by Forrest Jacobson or the department. But if you recall, many months ago now, Jane Raymond, her red flags, the department provided no information to Dr. Manley. We didn't give them any records. We didn't provide any updates. We didn't do jack. If you remember when Forrest Jacobson first got on the witness stand and I had an opportunity to question her, first thing I did was again show this referral letter, exhibit number 17. It outlined all types of information that had been supplied to Dr. Manley, including a recent 300 and some odd pages of Josh Powell's parents' divorce records from 1992. Information that was sent to Dr. Manley, so as he would go into and perform his psychological evaluation, he would have important details about the history of the Powell household back in the early 90s, and in fact, information about Josh Powell. That wasn't hidden. That wasn't buried. In fact, Dr. Manley testified that when he received the documentation, there was actually Post-it notes that Ms. Jacobson had placed on him to direct him so he didn't have to go through 300 pages if he didn't desire to, that pinpointed various accusations that involved Josh Powell. And so if you recall, when he went through what Ms. Jacobson had tagged when she testified, he confirmed that, yes, I received that information. But look at the referral letter that was sent. It included the dependency information. It included the non-parental custody information, the action that Mr. Cox has supplied a 10-page declaration. And if you remember, when I asked Mr. Cox on cross-examination, would you please point out in this 10 pages, the information you gave to Judge Nelson, important information because you want the custody of your grandsons. will you point out in this declaration where you allege any form of violence within the Josh and Susan Powell home? I ask you to look at the same because it's not there. It's not there. Josh's sister, Jennifer Graves, came into this courtroom and testified to you. And she said, well, I told Rocky all of this information about how I believe that Josh was assaulting his wife. That's not in Rocky's records. Look at it. Again, it's in Exhibit 55. Notes that were contemporaneous. Those notes were taken on September the 29th, 2011. They're there for you to review. But more importantly, Jennifer testified about all of the concerns she had and what she told Rocky and what she'd been telling people. What she failed to tell you that she also filed a declaration in that non-parental custody action on September the 28th of 2011. It included zero information about any physical violence within the Josh and Susan Powell home. I asked her to please point it out for us. It's important. We had Mr. Downing again at that hearing on September the 27th in front of Judge Nelson. She pressed him, what is the imminent harm, the facts that support that claim on these boys? The only thing he could come up with, their mother's has disappeared. She's gone. We suspect Josh Powell's done it. And Mommy Owie. Judge Nelson was fully aware of that. She was fully aware of it the next day when the department filed for dependency and there was a hearing. She was fully aware of that when she ordered visitation that would be supervised. And in fact, it was supervised. The highest level of visitation that the department has. Now, we have a lot of argument that's gone on that, well, the department should have had a secured environment. You heard from every witness who testified about the security, whether it was at a DSHS office. They said that, yes, there's a security guard at the entrance, but they don't screen people in. If something happens, they're told to let them flee. That's not security. We had testimony from Julio Serrano. We had testimony from Dr. Manley on visits they had at the Foster Care Resource Network, that it's an old house. Their security is a home alarm system, the same thing that many of you have at your own residence. That people are free to come in, they're free to leave, but we had to have it at a secure environment according to the plaintiffs. Visitations were discussed on transitioning to Mr. Powell's home, which you heard from Julio Serrano, again, the guardian ad litem, the natural progression. The natural progression that one would see in a dependency action. And that preferable, and the guides on visitation shows the number one preferred location is at a parent's home. Why is that? They testified it's because that way the children feel the most comfortable. It's an environment where they have their own belongings, where they feel like this is where I belong. That's why transition to a home occurs. In order not to keep these boys in an environment that they're not used to, that's strange, but for comfort level, as again, their needs are being looked at and taken care of. Now, we had conversations or testimony regarding Nancy LeMay and how that was totally, basically blown off. Nancy LeMay actually spoke with Forrest Jacobson on October the 14th of 2011. And just remind you, this was part of the Rock Club incident. Ms. LeMay actually, even after talking to Ms. Jacobson, sent a lengthy email. Read the email. It's there. It's an admitted exhibit. Again, it's all part of Exhibit 270A and 270B. Both are many of the most important emails throughout the life of this case. But what did Ms. Jacobson do with this information? She passed it on to Dr. Manley. She passed it on for purposes of his evaluation. And in fact, in exhibit number 18, which is Dr. Manley's December 2011 report, he talks about it. It's in there, it's included, along with a lot of other details. And what was the purpose of the evaluation report? It wasn't just for the department's information. That report was given to Judge Nelson, who happened to take concurrent jurisdiction, not only over the non-parental custody action, but also then over the dependency action. A person that had a wealth of information, even more so than what the department had in the early stages of this case, because of what the Coxes had provided to her already before the dependency even began. And then the information that was then provided through these different evaluators, these different professionals, these different people had eyes on these children and eyes on Mr. Powell. But here in mid-October, we have another person involved in the Mr. Powell's attorney, Jeffrey Bassett. We also had on October the 17th, the Family Preservation Services, the counseling within the Cox home commenced with Paula Strickland. We have monthly Forrest Jacobson going into the Cox residence to do what was called a health and welfare check, where she would go in and meet with the Coxes and then meet individually with Charles and Braden to find out how they're doing, if they have any concerns. That's, again, all part of her case notes. I encourage you to read those. It's all part of exhibit number 55. But the important fact that took place was on the 26th of October. Initially, at the shelter care hearing, there was a hearing scheduled, a status hearing for mid-November. And that status hearing would have been before Judge Nelson. But once Attorney Bassett became involved, he contacted the department and advised that Mr. Powell would agree to a dependency. So there was a hearing that was conducted on the 26th of October, 2011. An order that was also entered at that date, which just reaffirmed that Mr. Powell would undergo the psychological evaluation with a parenting component, which we heard testimony is the typical type of evaluation that is done in these types of cases. Not like Dr. Adler had testified that we're dealing with some form of dispute in a dissolution, child custody, where he gets involved and will evaluate for purposes of one parent or the other. This was a different form of evaluation, which is Dr. Manley has testified about at length. At that time, on October the 26th, we heard testimony from Mr. Long that, in fact, Mr. Bassett told Judge Nelson that Mr. Powell had obtained his own residence, that he removed himself from his father's residence, that he wanted to separate from his father in order to have his own home so that his sons could be reunited with him. The goal in these type of cases is always family reunification. That remained the goal throughout the history of this dependency action. But there was no rush at any time to dismiss the dependency. There was no rush to reunify without having all of the input from the professionals who were involved. And in fact, later on, you'll see that Forrest Jacobson, even prior to seeing any of these images that were subsequently provided by the state of Utah, filed a declaration with the dependency court asking Judge Nelson not to allow reunification. Not to allow reunification. We also heard that from Detective Sergeant Berg that that she and Detective Sanders many times would attend these hearings. But she admitted at no time did she approach the people that she had worked closely with for years, including Assistant Attorney General Long, to advise anything about your gut feeling. But more importantly, whatever information that Detective Sergeant Sanders had, and at this point we're reaching out to West Valley City Police asking for information that would assist the department in its dependency. We were even sharing information with them that really the department's on thin ice here because Mr. Powell is complying with what the court is ordering. The allegations believe that he may have had some involvement in the activities in his father's home, but there was no evidence coming forth to show that. We had his attorney pressing the department that this needed to be concluded. And the department is trying to delay and put off Mr. Bassett and Mr. Powell for time to learn more information and details. Now we heard from former Detective Maxwell. If you remember, I asked him a question that at no time during the course of the dependency action in the state of Washington did you provide any information as to past sex abuse or child abuse that you were aware of in the state of Utah to the state of Washington? He said that was correct. Now, we've heard from plaintiffs throughout this case that this is a domestic violence matter. We heard testimony from Judy Slaughter that when this came in, there was no one in the Stephen Powell residence where there was any accusation whatsoever of domestic violence. Who had the most information at that point in time of anyone? Detective Maxwell, lead investigator in Susan Powell's disappearance. The dependency action was commenced more than 21 months after her disappearance. It's reasonable for the department to ask the law enforcement agency to share information that would be relevant here in our state in their investigation. But once again, Rocky Stevenson and other social workers, their job is not to interfere and go out and start interviewing people out of state and interfering with a pending and active criminal investigation. So they're relying on who had the most information at this point in time. They've been involved in this investigation for over 21 months. And in fact, on the date that these little boys were killed by their father, still hadn't acted. More than 2 years later, almost 26 months. But the next question I asked Detective Maxwell, during the course of any contact that you may have had with Assistant Attorney General Long, when he spoke with you or communicated by email with you, was he requesting information for any evidence that you could share for the dependency action that he was involved in here in Washington State in order to provide it to our court concerning the safety of the boys? He affirmed that yes, that was being asked.
All right, Mr. Diaz, I think we'll take our afternoon recess for 15 minutes. Ladies and gentlemen, put your notepads down on the pews. Go with Kylie across the hall. I'm going to stay on the bench for just a minute to chat with the lawyers, and we'll see you in about 15 minutes. The higher up you get, the rises. It's like all right. So I want to discuss preemptory challenges, or excuse me, excusing the alternate juror. We talked at the beginning of the case, oh, so long ago, about every juror after number 12, which there were several then. Now we're down to juror number 13. Well, 15, but the 13th one, right? Anyway, that juror, which I'm perfectly willing to do. However, there has been sort of a persistent urging from juror number 9, who's moved from someplace to Fox Island or something like that. He wanted to be excused from further service after the 24th, and I politely declined his request. My concern is that he may want to rush through the deliberations in order to get to what he considers to be his more important personal business. So just put that out there for you, and if you can come to an agreement, then that would be fine, and I'll excuse juror number 9. But if you can't, then it'll be the last of the alternates, which I guess is number 15. Do you want to look at your chart?
We will. We're going to do that.
Are they in some kind of order over at 123? Or is it just like?
Yeah. It doesn't mirror this at all. It goes 1 to 4. It doesn't have like a.
The answer is no.
4, 5 to 8.
Okay. Mr. Buck.
Sorry,
9 wants to go. 15, who is the 13th juror now, would, according to the previous discussion, would be dismissed. Right. I don't know their names, but yes. There.
Do you want to give us an answer at a break or? We're ready.
What's your pleasure?
Keep it the way it is and, Mr. Nine, you're nine. Sorry.
Well, I'm not gonna tell him anything.
I know, it's going to, it's what,
All right. Your view, Mr. Buck, just because you are entitled to state your case.
Well, Your Honor, I guess my heart says we have 12 that are willing and noticed, and maybe we should use the one that isn't to be our for the very reasons that are laid out.
Well, I would amend your comment slightly. We have 12 that, of which one, we have 13 of which one has expressed an unwillingness. That doesn't mean that the others are enthusiastically willing to continue on. Yeah, and he came. I mean, and he's been, I got him right there. He was the one that we had under some kind of statement or something that he made right after we adjourned the first time, something like that. So, all right. Well, I said if there's not an agreement, we'll go with the original plan. So that's what we'll do. And it's all good.
Please rise.
Take your seats. So I'm thinking with regard to making sure all the exhibits are gathered, because this is, by my rough estimate, going to run us till 5 o'clock or a little after. I'm going to have to interrupt you at 4:30 to advise that I'm keeping the courthouse open because I have to do that. And I'm thinking that the best course of action will be to meet tomorrow morning, say at 9, so you can go over the exhibits with Mr. Mattson. You can make sure that all of the admitted exhibits are collected together, and you can assure us that they have been provided to the jury. Maybe we'll have the jurors come at 9:30 or something like that. But that sound all right? What? Good. No, don't worry. Yeah, you clear stuff. Nobody's going to be in here the rest of the week. After that, we're going to start selling your stuff on. So get it out of here. That's right. Can't encourage you to violate the law. Yeah, if you got a fire pit or something, I suppose you can do that. Rise from the jury. All right, please be seated, ladies and gentlemen. We're on the last lap, ladies and gentlemen. Mr. Diaz, proceed.
Just real quickly, I asked the security people to open past 4 3.
All right, noted.
Thank you, Your Honor. If it please the court. A little different topic. I'd like to start off on at the time when this CPS intake referral was made on September 22nd, it came in, and of course, as you've heard over and over from testimony, the allegations regard negligent treatment, maltreatment, and it was an intake showed that there was no domestic violence. Now, why is that of any importance? Well, the department has been accused of not following its policies and procedures. Mr. Buck, in his closing, showed you excerpts from Exhibit 70, the Domestic Violence Practice Guide, that the social workers hadn't been trained on the practice guide. If you remember Forrest Jacobson testifying that when that was originally, the term they used is rollout. When the policy was rolled out in July of 2009, all DSHS workers received the policy, the information. But as I showed you earlier, this slide of years of experience in these areas, people, domestic violence wasn't anything new. The guide was something that was adopted and new, but what's the importance of the guide? But to point you to the policy, to give you direction to where is the policy. And so I've asked many witnesses, including Dr. Rycraft, but also our social workers. where is the policy? You go to Exhibit 70 on page 15, it outlines the 3 locations in the practice and procedure guide where the policy can be found. We covered it. And you'll have Exhibit 293A, which was what was in effect in 2010 until November of 2011, that policy. And that was testimony from Ms. Rogers regarding when the policy changed, and there was an update. And there was some confusion because we went from a lettering system as to the paragraphs with numerical sections to now strictly numbers. But the policy did not change. There was the intake policy, which was part of that section 2220, which talked about an intake and how to fill out the form at intake. And you'll clearly see in the referral it says no, because there was no known history at intake that there was domestic violence going on in Stevens Powell's residence. And then in 2331 of that practice and procedure guide for 2010, you'll find then the other policies that are referenced in Exhibit 70, that DD practice guide, which were again were followed. If there's no domestic violence and there's out-of-home placement, you don't do a further assessment. Rocky Stevenson followed that policy. There was no further assessment at that time. It also goes and has it again that you interview the perpetrator. That was done. The person that was who believed responsible for the neglect, maltreatment, wasn't Stephen Powell, it was Josh Powell. And Rocky Stevenson interviewed him. Also, it calls for face-to-face interviews with the children. That was done. Not only was it done, they also had additional forensic interviews that were done at the ACA. And actually, Detective Sergeant Bird also participated and observed those forensic interviews. Policy was followed. This was not a domestic violence case. That was a theme that you've heard throughout the testimony from the witnesses that we've called. This was not a domestic violence matter. This was a neglect, maltreatment matter. And to be cautionary, the department advised the judge, who already knew from the non-parental custody action, that there was a disappearance involving Mrs. That was nothing that was ever concealed from the judge or the court. And in fact, every document you see from what's referred to as the ISSP's individual service and safety plans that were filed by Ms. Jacobson, the first thing you'll see when you look at those exhibits, and just so you know where to go find those, Exhibit 33 are the ISSPs that were prepared by Ms. Jacobson in October. And then you go to exhibit number and there are 2 exhibits, 245 and 246, were the ISSPs that Ms. Jacobson submitted to the court in January of 2012. But the first thing you'll see in each one of those is a restatement of all of the allegations. There's no way that the judge is going to misplace what was originally alleged, because it's repeated over and over again in these documents. But on the 17th of October, Rocky Stevenson prepared what was referred to as the SDM, risk assessment. And as he finished the completion of that, because of the facts that were known, it came out with a low score. So he overrode the score to give it a higher risk value. The higher the risk value, the more services within the guides that the department follow are available in that action, whether it's for the parent or if it's going to be for the child or children. And so he overrode the low risk to make it a moderately high risk. It's not the highest risk, which is high, moderately high. Now, going into the month of November, you'll see that with all of the blue shields on this calendar are contacts with either the West Valley Police Department or the Pierce County Sheriff's Office, primarily with Detective Maxwell and with Detective Sergeant Sanders. Each one of these entries, you're going to find emails. You're going to find the communications with these various folks. You'll see that there were still supervised visitations occurring. And in fact, on September 6th was the first supervised visitation with Miss Griffin Hall at Mr. Powell's new residence out in Graham. Prior to Miss Griffin Hall going out for that visitation in Graham, several days earlier on the 3rd of November, Dr. Manley and Forrest Jacobson had taken the boys. Forrest took the boys out to Mr. Powell's new residence for the first time. And there, Forrest did a walkthrough of the residence. Dr. Manley observed his second session, now observing Mr. Powell interacting with his sons. And that information is all contained in Dr. Manley's psychological evaluation. Again, a report that you haven't had the opportunity to sit down and read. It's exhibit number 18. I'm going to ask you to read that. It's 22 pages. Look at the details that are there. That information was all before the court at the hearing on February 1st. In there, you'll see information about Ms. LeMay. You'll see information about Josh and his comments and commentaries at the counseling session with Ms. Murigi. You'll see information about what was obtained from the divorce files, about all of these activities when Josh Powell was a teenager. None of that was hidden from anyone. It was there. It was there, and the court actually said that they reviewed it, which we would assume the court would do. But that was just one of many different reports that were filed for that hearing on February 1st, containing a wealth of information. So here in November, we have a number of activities, visitations, contacts with the police. That's when the department, initially with Rocky Stevenson and with the Assistant Attorney General Long, pressing West Valley, Utah for any information to assist us. You heard that from the Assistant Attorney General Long that Utah wasn't going to release anything unless there was a threat of the boys going home. So Mr. Long had to actually talk to Mr. Bassett and to encourage him to file a motion to convert the dependency to an in-home dependency in order to spur a source of information to come up with anything. But you'll recall that early on in early November, that all the department was being told that there was 5 or 6 images. Those are in emails. Please read those. But Ms. Jacobson, throughout the course of her work on the file, was receiving reports from Ms. Narigi, the now therapist for the boys, in order to help address any of their emotional or psychological issues that they had. We still had throughout the month of November, Ms. Strickland once a week going into the Cox residence to also provide the counseling therapy type services. You heard last week from Ms. Strickland how things improved over time. But you also heard from Ms. Strickland that Charlie and Braden, and really specifically Charlie, continued to press, I want to go home to my father. She said that it was evident that those boys loved their father. During this time, we also had disclosures that were being made, whether they were at visitations or elsewhere. for example, and I don't know if let it flip. Here we go. Here's an email which was Forrest Jacobson sending it to Gary Sanders. November 29th of 2011. She said, I wanted to inform you so that you can pass it along to authorities in Utah if you think it is appropriate that at the visit with their father this past Sunday, Braden told his dad out of the blue and not correlating to any conversation they were having, they found mommy's body in the desert. I have spoken to the visit supervisor who I've asked her to detail out the visit subsequent to that remark, as she stated it had an obvious effect on Josh. I also spoke with Mr. Cox tonight, stated that Charlie was talking on the phone to a friend of his peer from Utah when he stated, when asked if he would be coming back to Utah, that he would only be back in Utah if mommy came back, but that mommy might be dead. That information was sent to the Pierce County Sheriff's Department, to the liaison with the West Valley City, Utah. And you have Gary Sanders then advising Ms. Jacobson that he passed on the email to Detective Maxwell. The department's concerned. They were concerned throughout this entire matter. They're trying to do what's best for both those boys, at the same time recognizing that Mr. Powell had rights. He had rights to visitation of the boys, and for the best environment that available for the boys, that's where those visitations were now occurring. Moving along to December. Again, monthly, we had health and safety visits by Ms. Jacobson. She actually was out there on the 1st of December to the Cox residence, where she again met with the boys. Also discussed how things were going with the Coxes. We had on the same date, we had contact between Mr. Maxwell, or Detective Maxwell, and Assistant Attorney General Long, as we're still asking for release of any facts or information that are going to assist the department. We have concerns. Throughout the life of this, we've had concerns. You'll see emails in exhibit number 270A and in 270B, which you, again, will be going back to you. Communications back and forth with Dr. Manley. We actually had several of those emails we pulled out when Dr. Manley finished his testimony last week to go over those specifically. But that was just several emails out of quite a few number. And I encourage you again to read this information, read these details, see this communication, see what is occurring. But of course, the plaintiffs would have you believe the department did nothing. All we were interested in doing is covering it up. This is all just a cover up. Also in December, we had the session with Ms. Narigi where the inappropriate comments in the redirection that she was having difficulty with Josh Powell occurred. Well, not only is that noted in the case notes, which are part of Exhibit 55, it was also communicated to Dr. Manley, and Dr. Manley includes it in his report, the same report that went to Judge Nelson for her review and consideration at the hearing on February 1st. That information also was included in the Guardian ad litem report that Julio Solano prepared. I'll encourage you to see his report. That actually is a part of Mr. Bassett's emails that are part of Exhibit 278. You've got all the communication we had back and forth with Mr. Bassett. Those are all exhibits that were admitted when Ms. Jacobson testified back in early March. And included in there is Mr. Serrano's report. I want you to read his report, the report that was given to the court. In there, it talks about these comments that the boys are making. Comments also included that you want to do something about my father, and I'm paraphrasing, because he'll kill you. Information that Judge Nelson was fully aware of. Look at her order that was entered on February the 1st. Her order is exhibit number 257. There's actually two separate exhibits. One that was for Braden's action, one for Charlie, because they have separate numbers or separate orders, but they contain the same information. And you'll see within that order that it indicates that she received a guardian ad litem report. She checks it, she initials it. That was just one of many reports that she was provided. She also indicated that she had received the ISSP from Ms. Jacobson. Read that ISSP, because the plaintiffs would have you believe that there's just a sentence that was in the ISSP. But there's a culmination of various reports that are all being provided to the court. And we know that on February 1st, when Judge Nelson ordered that Mr. Powell submit to a sexual evaluation with a polygraph, that she was fully aware of vast amounts of information regarding Joshua Powell, the disappearance of Susan Powell, the Stephen Powell situation, the charges against Stephen Powell, the house of horrors that were described by some of the detectives who failed to put the boys in protective custody when they found this so-called house of horrors. A lot of information contained in those records, and I encourage you to read them. So here we are in December. We now have Pastor Atkins who's come forward, and it has been offered up as an additional supervisor to supervise visitations. You have all of his reports are in these exhibits. You can see exactly what he wrote, what he provided to Ms. Jacobson. And you heard him testify. You heard him testify that he was receiving, as a pastor from his congregation, pressure to separate himself from Mr. Powell. But you heard him testify that those boys loved their father, and that he believed everything he observed, that the feeling was mutual between father and sons. He also testified that probably out of anyone in the locale, since Josh and the boys had relocated to Washington State in January of 2010, he probably had the most contact with Mr. Powell and with the boys, because he had testified that he had children that were similar age who actually went to the same school, eventually where Charlie was going. So read what Pastor Atkins wrote. Before I move into January, another important note was Ms. Griffin Hall, and you'll see emails again that are contained in the exhibits, where she states that as a contractor, they don't work legal holidays. And so there were, Mr. Powell had asked for Christmas, and some other holidays to spend with his sons. But Ms. Griffin Hall had to advise that I don't work on holidays, legal holidays. So Pastor Atkins stepped forward and said, on Christmas Eve, I'll take the boys to your house. And in fact, he testified about Christmas Eve, taking the boys to Josh's house. Josh had Christmas tree and gifts for the boys and had things decorated, pictures of Susan Powell present in the residence. And that they were there for several hours, and then to complete the visitation, they all returned back to the Atkins residence for dinner. Read Pastor Atkins' reports. But moving into January, you'll see in the emails, and you'll see again on this calendar that's on display, all the blue shields. We're still trying to get information from West Valley, Utah, where they had advised, no, we've got 5 or 6 images, but they also advised the state that they're subject to not only a gag order, but a secrecy order. And that they just can't disclose information without permission. One of the exhibits that you'll have an opportunity to see is a copy of an order that released what ended up being more than 300, perhaps up to 400 images, thumbnail type images of cartoon porn, some of it sensual, that Dr. Manley testified about, which then, from that, led to Dr. Manley doing an addendum report that he submitted on the 31st of January of 2012, where he recommended the psychosexual evaluation of Mr. Powell. He also recommended that there not be consideration at that time at the review hearing, which was actually the following day on February 1st, that the court consider reunification, that it was too soon, that Mr. Powell needed to be evaluated. And in fact, in January, he had actually started counseling sessions that had been recommended and the department supported, that Mr. Powell received separate PhD psychological, clinical counseling. And we just heard this past week from Dr. Whitehill, who was providing those counseling sessions. We also heard from Dr. Whitehill that he last saw Mr. Powell on February the 3rd, 2 days before Mr. Powell killed those boys. And that there was no indicators that from the 60-minute session that he had with Mr. Powell that would lead him to believe that he was either suicidal or homicidal. And as a psychologist, we've heard from doctors that they have a duty to warn if they have any information whatsoever that a patient or someone they're treating could be a threat. So finally on the 17th of January, which was a date that finally received word through Gary Sanders that the secrecy order was lifted to allow some imaging to be sent to 8 people in Washington State who would be permitted only Detective Sergeant Gary Sanders' office to view, and that those images could not be loaded onto any computer, they could not be printed, and that the order specified the 8 people who would have permission to go to Detective Sanders to view them. Word came out on the 17th of January that those were being released, and later, at the end of that day, they had been. But prior to that, Ms. Jacobson had prepared in response to a motion to place the children in an in-home dependency, a declaration opposing reunification, advising the court that the department that they were expecting to receive imaging that had been promised for months from Utah. Her declaration is Exhibit 251A. Please read that. The motion that was filed by Mr. Bassett, which you'll see some of the communications again where Utah is saying, well, we can't release anything. But if there was a threat that the boys might be returned home, then we might be able to give you something. So Mr. Bassett actually filed in early January, it was on the 9th of January, filed a motion to request that Judge Nelson convert the dependency to an in-home dependency and send the boys back to Josh. That's Exhibit 249A. Read that. A lot of detail in there that Mr. Bassett placed in there, all information read by the court. She denied the motion on February 1st, but it's detailed. There's information about the visitations. There's information about Mr. Powell and his comments. There's information which Judge Nelson was aware of. Information that Judge Nelson was aware of when on February 1st, she also ordered that visitations continue as is, knowing full well that the visitations had been occurring in Mr. Powell's residence since November, knowing full well that she had just ordered the psychosexual evaluation, knowing full well that if there was pressure or risk that she could limit visitation. She had the power to do that. The department couldn't stop visitation. The department doesn't have that power, but the court does. Court was fully advised throughout this matter. Plaintiffs criticized, well, it wasn't timely. Judge Nelson was advised about all of the derogatory, disparaging comments that Mr. Powell made over the course of several months. Mr. Serrano was aware of it. It's in his report. You can find his report in exhibit number 55 on page 37. Actually, that's the wrong page. That's Jennifer Graves in the note with Rocky Stevenson. You'll find in exhibit 270A is where you'll find the report on page 55. And you'll see that Mr. Serrano, you'll see exactly what information he had. You might remember when he testified, he didn't have the best memory. I had to ask him several times to see if he would recall information. And again, he wasn't the best historian. But the report he filed in early January, it's got contemporaneous information that he provided to the judge. And in that report, he recommended to the court, the advocate for the boys, for Charlie and Braden, he indicated to the court that Mr. Powell, that he was in compliance with everything the court had ordered. He also indicated to the court that he was progressing, which is what they look for in the natural progression of a dependency. And in fact, based on that, you'll see in the order that Judge Nelson entered on February the 1st, in her order, she had the same finding. Read her order. It says that Mr. Powell was in compliance and he was progressing, knowing full well about the derogatory, disparaging comments, because it's not hidden. It's in a number of documents that was before the court on February the 1st. Most of those documents were filed in early January of that new year, 2012. I wanted to share with you, just to recall and refresh your memory about Detective Maxwell here just a week ago testifying again, where I asked Mr. Maxwell, do you recall that you had no concerns regarding sexual abuse or child abuse directed at Charles and Braden while in Utah? He goes, I was not aware of any child abuse or sex abuse. I go, now, Mr. Maxwell, if you had information regarding past child abuse or sex abuse of Charles and Braden in the state of Utah, would you have notified Mr. Stevenson or other representative of either Child Protective Services or Department of Children and Family Services during the course of a dependency action here in Washington? He goes, yes. Now, there's been a lot made of Mr. Stevenson in that he prematurely closed his investigation. Well, he testified about the normal course of a CPS investigation, and they actually have timelines that they need to comply with. But due to the fact that that was unfounded was the finding and it was closed the end of November, didn't mean that Charlie and Braden were going home. It didn't mean the dependency ceased. What it meant was the CPS investigation was concluded. But in fact, Mr. Stevenson continued to communicate with Utah, trying to assist by getting the images and any other information that West Valley, Utah had. And he continued to communicate with the Pierce County Sheriff's Department for their assistance. He didn't give up. As you heard from Assistant Attorney General Long last week, that's an administrative finding. It has no bearing on the dependency. The dependency continued. And yes, the ultimate goal of the dependency is family reunification. And that was still the goal. But that didn't mean those boys were going to go home. Services were going to continue. And based on what the evaluation was of Josh Powell, the court would have dealt with that. So, over the time from the very first contact, March of 2010, until February of 2012, we've noted for you the number of contacts law enforcement had with the department. There were 60 contacts. 60. And many of them, again, are noted in the case notes. They're also noted in emails. They're all for your review. Now, we had people that had testified during the course of this trial that they had no information about harm or abuse to these boys. We had social worker Forrest Jacobson, Rocky Stevenson, Betsy Rogers. We had Michelle Breland from the Child Abuse Intervention Department at Mary Bridge Children's Hospital, who did the sexual assault, physical assault examinations. Her reports are there for you to review. They're part of the exhibits. You had Dr. Mike Whitehill, who also testified that he had no information or evidence. Paula Strickland, Elizabeth Griffin Hall had no knowledge of any prior harm or abuse. We also had law enforcement, Detective Gary Sanders, Detective Sergeant Teresa Berg, Ellis Maxwell, Steve Downing, the lawyer for the Coxes in the non-parental custody action. He never provided any information to Judge Nelson of any evidence whatsoever of physical harm or abuse that was known for these children. Mr. Cox himself never provided any information. Jennifer Graves, we went over what she said, and that she filed a declaration in support of the Coxes in September of 2011, and they made one mention about harm or abuse. And in fact, read Mr. Cox's declaration to see the information regarding any type of abuse, whether it's domestic or otherwise. If you would call me asking him on cross-examination, would you please point out in these 10 pages any reference to abuse regarding your daughter? There was 2 places. One said emotional and verbal abuse. On the next page, it referenced again emotional abuse. That's it. That information was before Judge Nelson. Also to Julio Serrano, the guardian ad litem, who was assigned by the court as a special advocate for the boys. He didn't work for the department, but he was a decision maker with the department, not only on relocating the visitations to Mr. Powell's residence, but also increasing the visitations. He also was involved in approving Pastor Atkins as a supervisor. There's a number of eyes, not only on Mr. Powell, but on the children that were involved throughout this entire process. None of them suspected that Josh Powell would harm or abuse his sons. So we had Forrest Jacobson. She was asked, actually by one of you, do you believe at any point that Josh would harm the children? This was on March 5th, when she was ending her testimony that day. Her response was, I honestly have a hard time thinking about what happened. It was never on my radar from the information that was available to us that he would physically harm the children. My worst case scenario was that he would try to flirt with the kids. He had been the suspect in his wife's disappearance for 21 months before we stepped in and filed a petition. There was nothing indicated he had physically harmed the kids. No information indicated he would. And they had already been taken once by law enforcement and interviewed. It was not something I thought was going to happen. So again, we have law enforcement taking these boys out, interviewing them, and returning them back to their father. That was known by Assistant Attorney General Long. Who was involved in the dependency action. But then we had Detective Sanders, his testimony on February the 27th. And throughout the life of this case prior to the murder of the boys, you didn't have any evidence that Josh Powell struck his boys or physically abused, committed physical child abuse on his boys. The answer was no, we did not. If that would have happened, I would have arrested him. Then we had Detective Sergeant Berg here on July 14th testify as follows. At any point, did you ever come to knowledge of Josh Powell physically harming the boys prior to their death? No. And throughout your investigation and time, when you were working with West Valley PD, did they ever relate to you that Josh Powell sexually or physically harmed the boys? No. The lead investigator, Detective Maxwell, July 21st, he testified to this question. And do you recall being asked at that time whether or not you had communicated any concerns about the boys to Washington State? His answer, if I remember correctly, I did not express any concern as far as their welfare because I didn't have anything. I didn't have any evidence that they were being abused. So another question I asked him, same date, July 21st, Mr. Maxwell, do you recall that you had no concerns regarding sexual abuse or child abuse directed to Charles and Braden while in Utah? Answer, I was not aware of any child abuse or sex abuse. This is the lead investigator of Susan Powell's disappearance, his testimony, and when the boys were put into protective custody, more than 21 months had passed, and he had been involved in that investigation. On the 22nd of July, I asked, did you state any concern that Josh Powell would harm or possibly harm the children of Washington Social Services? His answer was no. and I'm gonna skip over, we've got testimony from ARNP, Michelle Breland. We have the testimony that you just heard last week from Dr. Whitehill. Testimony from Paula Strickland about what she knew. Well, and if you recall, I asked, during your interactions with the Powell boys, Charles and Braden, did you learn at any time from either one of the boys of any alleged physical abuse or harm that had been perpetrated by their father, Joshua Powell, on them while in Washington State? No, I did not. That was on July 23rd. I also asked her, but during your interaction with the boys over a course of about 3.5 months, did either one of the boys indicate that they feared being around their father? She said, no. That was part of the problem with the adjustment initially, is because Charlie, of course, who was the very, very verbal one, wanted to be with his dad. He was very clear, I want to be with my dad. And I think that's part of why he resisted the grandparents, because, well, he said it. It's not what I think. He said because he thought if he liked it there, he would have to stay longer. And his goal was to get out with his dad. We asked Mr. Downing when he testified on March 2nd. Now, at the time of the non-parental custody action, did you advise the court of any known physical harm or violence to Braden and Charlie that had been perpetrated by their father, Joshua? His answer was, not that I can remember at this point. Well, do you know if there had been any known facts of any harm or violence to? He cut me off and said, I do not. Mr. Serrano on March 16th was asked, if allegations were the same for Josh Powell through the whole case, then why did visitation get increased or moved? Again, he's the advocate, special advocate for these boys. So the reason why the children came into care was because there was an investigation in regards to Stephen Powell's home. The children came into care based on that. There was really no allegation that he abused or neglected his children. There was more of the stuff that was happening in that home. So we demonstrated throughout this short review period from the time that he agreed to the order of dependency to the first review hearing, he demonstrated that he could properly care for his children. Now, I'm not going to read the rest of that because that's the same observation that Dr. Manley had, and read his report regarding visitations. Here, Jennifer Graves, February the 25th. What was the purpose for the declaration that you signed and filed with the court in 2011? To help reinforce the fact that Charlie and Braden were better off with Chuck and Judy, that they would be safer in their custody than with my brother and my father. Are you able to, within the 3.5 pages of this declaration, explain to the jurors where in this declaration you advised the court that you believed that your brother was going to harm Braden or Charlie? I don't know that I put it in this. What was the purpose of the declaration then? Did you mention to the court any domestic violence between your brother, Josh, and your sister-in-law, Susan? I did not specifically say that in this document, but she claims later that she told Rocky, which I believe was the very next day, if she told Rocky that, it would be in his case note. Read that case note. So during the dependency and resolutions, as we went through the dependency, we just indicated that many of the allegations, they were either resolved or Mr. Powell had removed himself because, again, there was concern about safety in the Stephen Powell residence. The boys never returned to that residence. The date they were removed and put in protective custody, they never went back to Stephen Powell's residence. Now, we submit to you that undisputed facts before Judge Nelson include an allegation in the Powell's parents' 1992 divorce action were evaluated and reported in Dr. Manley's reports to the court. That Mr. Downing informed Judge Nelson that the Cox family feared that Josh could turn on his wife, he could turn on his boys. Now, we heard some testimony about that from Assistant Attorney General Long just last week. That's something Judge Nelson was aware of. That statement was made directly to her by Mr. Downing. This is all information she had when she entered her orders in her last order on February the 1st. Judge Nelson had the power to regulate all visitation in that dependency action. During the October hearing, Judge Nelson was advised by Jeffrey Bassett about Josh's relocation to his own residence. Then Jeff Bassett filed a motion for the in-home dependency with information that you're going to read in that exhibit. The ISS piece filed by Ms. Jacobson has detailed information, and I would encourage you to again review that. So we heard and we saw these slides that Ms. Raymond was provided in her direct examination as the first witnesses for the plaintiff. The first witness for the plaintiffs. Ms. Raymond, who last worked for the state of Washington in 1985, she testified that she had been initially around 1985 engaged by the state on approximately 30 cases as a consultant, potential expert witness. But after that date, she's handled approximately 170 more cases she testified to, all for the plaintiffs. All for the plaintiffs. I would submit to you that Ms. Raymond's testimony is subject, is biased, and you should evaluate it that way. But here, these red herrings, that the CPS, they closed their investigation too early and therefore closed the case on protecting the boys. The only thing that was closed, according to their policies and procedures, was the administrative part of the CPS investigation with an unfounded finding. It didn't stop anything at all regarding the dependency, the services that were being provided, and were ongoing at the untimely death of these boys. That DSHS should have conducted a DV assessment throughout the life of the case. Well, we heard earlier at the testimony from the workers, this was not a domestic violence case. And as much as the plaintiffs want to make it so, it's not. DSHS should have contacted collateral sources in Utah regarding Joshua Powell and Susan's relationship. Well, one, we contacted the lead investigator for the investigation into her disappearance. And you heard that we don't interfere with police investigations, and there was 2 of them that were actively ongoing. Josh Powell had not been ruled out of the charges and the information, the child porn that was found in his father's residence. She also said that one of the red flags, red herrings, that Joshua had delusional thinking. Well, we went over that with Dr. Manley concerning where the word delusional was and in what context. Things need to be put into a proper context. Now, in concluding here, several things I wanted to bring up. And if you're several of the other exhibits that I think you would have interest in is Exhibit 307, an email from Rocky Stevenson, which corrected Detective Sanders when he said that we weren't aware that he got a new residence. Well, in fact, on November the 4th of 2011, Mr. Stevenson sent Mr. Powell's new address to him so he'd be aware of Mr. Powell's new residence. Also, Exhibit 331. That's an email between Elizabeth Griffin Hall and Forrest Jacobson. And Forrest is advising Miss Elizabeth Hall that they're considering moving the visits to Mr. Powell's home. And Miss Jacobson inquires and asks if she's comfortable with that move. Her response is Exhibit 331, and you'll see the communication there. Communication also included guardian ad litem Serrano. You'll see in the orders that were issued by the judge, visitation decisions had to be in conjunction with not just Forrest Jacobson, but with the guardian ad litem. We aren't making unilateral decisions here. People are being considered and consulted. There was multiple eyes in this case. Now, we heard from Dr. Clifford Nelson here sometime about 2 weeks ago. And we've had 3 different doctors testify about the injuries that were sustained in this matter by Charles and Braden. And I submit to you that Dr. Nelson was the one with the most relevant information, where he said that as soon as the boys were struck by their father, that the injuries that were sustained subject them to be unconscious. And as they were unconscious, they had no pain and did not suffer. He explained to you how the ethanol from the gasoline could be absorbed into their systems, but you've heard the testimony about the devastating injuries that were caused from being struck by Mr. Powell, what he did to his sons. I'm going to submit to you that Mr. Powell is the sole cause of the murder of his sons. It was not due to any negligence by the state of Washington. It was Mr. Powell who did this. There was no history of prior abuse, no history of any prior harm that he had ever subjected his sons to. And it was reasonable and not foreseeable. Now, I'm going to ask you 2 things. The jury instruction for entities, acts, or admissions, and not by what the facts and circumstances may appear to have been after the time of occurrence. Throughout the course of this trial, we've heard so many new facts, so much new evidence that was never known to the state of Washington. We had all kinds of details. In fact, if you recall, I asked this psychiatric expert, Dr. Adler. He was talking about seeing forensic interviews with Charlie the day after his mother disappeared in Utah. And I asked him, where did you get that information? Because you've heard testimony from former Detective Maxwell that it was subject to a secrecy order in the state of Utah and a gag order within their department. I asked Dr. Adler, well, aren't you, in hindsight, evaluating this case? And if you recall how he would spin things, he sat there and told us, well, I don't think it's hindsight. I asked him to define it for you. So it's a long time ago. I'm sure you might not recall that, but this instruction is about hindsight. And we believe that that has an effect on people's perceptions. The special verdict form that you've been provided, the very first question was the state of Washington negligent? We're going to ask you to answer that no. Once that's done, whoever you select as your foreman should sign this and return it for the court's consideration then. I'd like to